Let the buyer beware. This is a concept in real estate and like in most things. Buyer beware was a big concept. And then a lot of states also started to look at that and say, is that really, fair, blah, blah, blah. And a lot of other states came up with these consumer protection laws. You might see unfair, deceptive acts and practices called different things in different states, right? So which kind of started to replace this concept of caveat emptor. But let the buyer beware, this Latin phrase caveat emptor, is something that we definitely want to know for real estate exams. So what does it mean? Caveat emptor means it is a principle in real estate stating that the buyer themselves are responsible for conducting their own investigations and inspections of a property's condition to determine its suitability before you buy. So the weight sits squarely on the shoulders of the buyer. And that's what buyer beware means, caveat emptor. And in conducting this due diligence is another fancy vocab phrase. Basically what it means are, in real estate, for conduct home inspections, reviewing certain documents to make sure they're authentic and everything else, evaluating environmental risks, assessing financial factors, and researching market conditions, all of which are due diligence that the buyer must perform in order for them to make an informed decision. Now, it doesn't mean that the buyer has to do all of these things by themselves. Obviously, you hire attorneys and environmental experts and home inspectors and so on and so forth. But those folks are helping you to determine the viability of this acquisition. Now, we also do know that if certain things weren't disclosed to a buyer by a seller or their broker or something like that, where we hid a defect or something like that, those types of things will be grounds for a consumer protection issue potentially if a professional in a business purposefully in a wanton way makes misrepresentations or even negligently makes misrepresentations to help their client versus the buyer, right? So again, that's a whole other discussion, but in the term of caveat emptor, you definitely want to know what it means. Let the buyer beware, and kind of understanding what some due diligence points are and what falls on the shoulders of the buyer in this particular question. The Superfund. What is this thing? We learn about it in real estate courses. The Superfund is something of significance to a test. You will definitely see it in practice. You see the Superfund. Their environmental issues are environmental issues, and they could adversely or significantly impact the outcome of a real estate transaction. So let's take a quick peek at what is the Superfund and kind of talk about that. All right. So the Superfund is a federal program established by CERCLA. CERCLA is the big U.S. environmental law, the Comprehensive Environmental Response, Compensation, and Liabilities Act. And that addresses the cleanup and the remediation of sites that are contaminated by industrial pollution, chemical spills, or improper waste disposal. It provides funds and authority for the Environmental Protection Agency and the state-level environmental protection agencies, many times called like the DEP, the Department of Environmental Protection, to assess and clean up these hazardous waste sites which pose risk to the public health and the environment. If a property has been listed as a Superfund site, this information must be disclosed to potential buyers. Under CERCLA and the Superfund amendments of 1986, both current and previous property owners can face liability for environmental violations even if they were unaware of the violations. So basically what this is this is sort of an environmental law coupled to CERCLA. So the Superfund is CERCLA and the fact that we put away a bunch of money to deal with environmental issues here in the United States, and that the EPA or the local DEPs can access these Superfunds to clean up environmental catastrophes on U.S. soil and then figure out who the primary responsible parties are or who the responsible folks are. It could be a previous owner of the site in many instances, or it might be the current owner, but it doesn't absolve previous owners of the site. So there is some, there is some exceptions here, but you want to know for the most part that that's one of the biggest risks in real estate as an asset class is the environmental issues. Now you know what the Superfund is, a bunch of money that we set aside according to CERCLA, this big federal law for environmental issues, and you want to know that the EPA on the federal level is the Environmental Protection Agency. CERCLA and the Superfund are definitely some things that you see crop up on exams, so look out for them, and we'll see you in the next one. Defects and disclosure, and material facts, material defects, and latent and patent defects are all absolutely vocabulary phrases that we want to know. Let's get into it. Let's talk about what each one of these are, and I'll give you some tips and tricks to think about. All right, number one, material facts are any bit of information about a property that may influence a buyer's decision. The buyer's decision might be adversely impacted if these facts of information were not presented to them. In other words, the property's condition, features, history, and legal status all have importance, and these are all considered material facts of information. All right. Material defects. Another category and another vocab phrase, a material defect is a significant issue or flaw in a property that affects its value or safety, something that could adversely impact the health or safety of an individual or group of people. Known structural problems, safety hazards, environmental issues, or code violations all fit here when it comes down to material defects. A classic one that you see on real estate exams many times is lead paint. Lead paint has to be disclosed. So known defects have to be disclosed. Those are material in nature. Things that you can avoid when it comes down that are not material defects are things like psychologically impacted property conditions, stigmatized properties, hauntings, that kind of stuff, murders, those types of things. Check your state in where you're sort of doing this and try to figure out where those are. And in our state, for example, you don't have to disclose those particular defects. They're not considered material, although some people might say, hey, I believe in ghosts, and that is a pretty material, significant fact for me. You need to tell me that. Well, in some states, they say, no, you don't. So you want to check your state to try to figure out what defects are considered material defects in nature and what are considered sort of immaterial and do not need to be disclosed. Okay, those are important. And then the final one here is latent defects. And these are hidden or concealed flaws in a property that are not readily apparent during a reasonable inspection. The exact opposite vocab phrase with latent defects is something called a patent defect. So latent and patent are the opposites in phrases when it comes down to defects. And these may include issues with the foundation, plumbing, electrical systems, or pest infestation. All right. All of these are definitely things we need to know. Material facts, material defects, latent defects, and patent defects. Study them. Want to know these. They like to ask a lot of scenario-based questions here. They like to ask questions that cross-sect with agency and fiduciary obligations and the obligations of disclosure and everything else, which is why many times testing companies put all of this stuff, environmental and disclosures and defects and everything, into one area where it comes down to disclosure. Okay? Good luck with your studies. We'll see you in the next one.